Good evening, student. Today we will be going with the second topic or second important aspect of the succession, that is the female intestate, and especially the changes that has been brought under the 2005 amendment. Uh, Women always has constituted the half the populations and perform nearly two-thirds of its hours and receive one-tenth of the world's income and less than 100% of the world's property. Developing countries continue to experiment with egalitarian property right from the Columbian regiments. But today, in family law, in the family law and the India's 2005 Succession Amendment Act, uh, also has created that stranded reformations, the stranded between the converted inheritance laws and ambiguous customary dikkats. Women in India are not only ignorant of their rights, especially inheritance, but believe that they are not meant to hold the property. To remove this particular indications, it is believed that the independency of women independency of women from noble families is a must, and it is for this reason that the 2005 amendment has taken place. The Amendment 2005 is just an attempt to discriminate the contentment in the Section 6 of 1956 Succession Act, giving equal rights to daughters in the Hindu Mitakshara. The amendment 6 devolves with the devolution of the interest. 6.1 provides daughter as a coparcenary, just like the son, and also she can have her own rights in the same manner as that of the coparcenary son. She shall also have the right subject to same disabilities and liabilities. She shall be deemed to include a reference to a daughter as a co-partner, but this provision does not apply to a married daughter before the commencement of the 2005. In Prochuri Samhasava judgment, it was being opined that daughter becomes the co-partner after the Hindu succession. The rights of the daughter as a co-partner arises only after the 2005 amendment. Further, the 174th Law Commission report, with the with the omission and with the introductions of the 2005, deleted the major gender discrimination that was in Section 4, Clause 2, which made the woman inheritance right in agricultural land equal to men. Furthermore, the Section 15, one of the most important section in the Hindu succession, which specifically talks about how the property of the Hindu female is to be devolved, containing certain discriminatory provision. It states that in the absence of class 1, now please understand, as I've said in the previous online session, the distribution is usually done on the class heirs based. If the person is writing testamentary and if the person died deceased with will, and the females, if dying without making intestate, the property distribution will be followed as per the class heirs. So basically, in the absence of class 1, that is the son, daughter, husband, the property of the husband's heir, the property of the female will go to the heir of the husband, and only if these heirs are not there, then upon her father and mother, and so on. However, in the absence of mother and father, the property will again devolve upon the heir of the father. And if there is no one in the father's side, then on the heir of the mother's side. The next is the comparison. What are the comparison between the unamended 1956 and amended Hindu Succession Act 2005? Section 6 before 2005, son was the only independent birthright as a co-partner, but post 2005, not only son but both son and daughter have the equal rights. Second, Section 4.2 before 2005, inheritance of the agriculture was subject to state level tenure laws, and not to the women. But after the Hindu amendment succession, the inheritance right in all agricultural land are subjected to the Hindu Succession Act. Next is the Section 23. In the dwelling house where the members are residing, no female heir can claim partition. But after 2005, daughter, whether married or unmarried, have the same rights to reside and to claim partition of the parental dwelling. Similarly, Section 8 is also to be referred, which talks about the males intestate successions, males devolution of succession. The class 1 heir of Hindu male includes the children of predeceased children, but these are recognized up to 2 generations for the predeceased. Post 2005, the predeceased daughter, the class 1 heir of the Hindu male, will include up to 2 generations of both son and daughter. Earlier, there was only son, but now post 2005, both son and daughter share the equal derivations of the devolution. And Section 24, a widow is entitled to inherit the intestate property as a widow if on the date of succession she has remarried. But after 2005, a remarried widow can inherit the property even if they are remarried. So basically, these are the major changes that has taken places, and especially to the females after 2005. I hope that this will be very much important to, and you will be able to get the grip. That was all for this session. Thank you and have a nice day.